Good afternoon, everybody. I will call to order this meeting of the Ad Hoc Bylaws Committee of the Del Mar College District. We're convening here in the Eisense Boardroom at Del Mar College. And I am going to call the roll to ensure that we have a quorum. Regent Turner?
Here.
Regent Hutchinson?
I'm here.
And I'm Libby Averett, and all members of this committee are present. Please join me in a moment of silence, and we will follow that with the Pledge of Allegiance. Please join me in the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. If you'll join me now in reading the Del Mar College Vision Statement. Del Mar College will be the premier choice for life-changing educational opportunities provided by responsive, innovative faculty and staff who empower students to improve local and global communities. Del Mar College is streaming live audio and video from the official Ad Hoc Bylaws Committee meeting on the college's website in real time, with the exception of portions of the meeting considered as closed session by statute. We did provide opportunity for public comment for today's committee meeting, and I've been informed that we do not have any public comment submitted today, so we will move on with our regular agenda. First up is the approval of our minutes from our last meeting on July 29th, 2021. Those were provided to us ahead of this meeting and also today. Are there any corrections that need to be made to the minutes? Is there a motion to approve the minutes as presented?
I so move.
Thank you.
I second.
Thank you. We've got a first by Regent Hutchinson, second by Regent Turner. Any discussion? All in favor say aye.
Aye.
Aye. Any opposed? Okay, thank you for helping me take care of that little piece of business. We did, as a summary, we did present a draft of our work to the Board of Regents at their regular board meeting in August, and they did have overall they were well received, very well received, and they were appreciative of our work. We do have a couple of paragraphs that we wanted to do some additional work on, and I know that Mr. Rivera has been doing that for us and has provided us with some potential edits for our consideration today. Mr. Rivera, I'll just turn it over to you if you want to sort of guide us through what you've got in front of us, what we have in front of us now.
Be happy to. Thank you, Regent Averett. Regent Hutchinson, I emailed them a couple of hours ago. Were you able to receive them?
I did. I
Okay.
have these. I have the two: the personal disclosure statement and the section on statement of conduct and ethics. Is that right?
That's correct. That's correct. Just wanted to make sure that we were actually on the same page. So, Regents, you got a lot of good feedback, a lot of discussion at your August 10th board meeting, and I'm hoping that I identified correctly the specific provisions that the board wanted you all to take a little bit of further look at. And you'll see I've got them in the handout that I passed out. There are 3 sections. What's highlighted is what I want to direct your attention to, and you'll see that I've got what you have currently and then what I've come up with as proposed. Now, as I indicated in my communication to you, these are draft, so please, think about them and provide input. You'll see that with respect to subpart W, all 3 of these sections are under the Statement of Conduct and Ethics, which is section 2 of your bylaws. And the provisions are F, U, and W. W, probably no surprise that I have 3 different options for you to consider, given the amount of conversation that sparked. And I'm not saying that any one of these is even, yeah, so this is, in fact, Regent Averett has a contribution in here, and then I went back to one of the guiding pieces of best practices that I've been relying on, and that's the American Law Institute Principles of Law. It's a work in progress, but I think I told you all that I'm involved with a very large committee that's been reviewing government ethics and trying to put together a legal treatise or an authority on that. And of course, they're trying to write ethical provisions for Washington, for folks who are in regulatory agencies, and it's a lot more complicated. So my job has been to try to take those principles and synthesize them and make them fit your size, because I realize that you're not going to have the same kind of back and forth perhaps that they do in different places. So that what you see in yellow is sort of my best effort based on the input that was provided during the August 10th board meeting, and a little bit of editing. And then the other item that, again, generated some discussion was the personal disclosure statement. And you'll see that I've made a couple of proposed edits there, both to the first part and then added an additional one that came up. And I want to go through that with you. Regent Hutchison, I have this, I handed out to Regents Averett and Turner an excerpt from the actual personal financial statement that is the form provided by the state, the 28-page document. I didn't make copies of all of them, but just excerpts. But hopefully you'll be able, I should have emailed it to you, but hopefully you'll, well, I guess, no, that's not attached, I'm sorry. Hopefully we can walk you through it and you can see what we're trying to do here. But so that's sort of setting the table, and we'll just take it up with the first one. The provision F, which talked about avoiding contact with vendors or contractors or bidders or applicants during a pending process. And you'll see that I've added in there, because that was a suggestion I think that was made, right? That you may designate a representative who can provide information or answer questions from the public. So that, I put
So
that
what
at
does
the,
that mean?
So and
So
just for
I can-
anybody who may be listening, Dr. Turner unfortunately was not able to be at our August 10th meeting. What came up is if somebody does contact us, particularly applicants who may be interested if we're appointing a regent, and let's say that they have submitted their application and may want some additional information, that instead of us just saying, I'm sorry, I can't talk to you, that perhaps we as a board may decide to direct those questions to the chair of the board or to Mr. Rivera. So, and basically this just says we may designate, doesn't say we have to, but we may, if we think that we're going to be getting some questions.
Gotcha.
Mhm.
Okay, that's fine.
I
Yeah,
think
just-
I think this captures and addresses the concerns that were voiced at that meeting.
So do you want to add that in there? The board may designate a representative such as legal counsel or the chair? I mean, or you just want to leave it like that?
I would
don't
recommend
know.
leaving it like that.
Open.
Okay.
Because it could be Dr. Escamilla.
Sure.
Or it could be,
Okay.
some other member of the executive team that's
Okay,
appropriate.
then we don't have to go back and
Right.
change anything.
Right.
we
It
just
could
leave
be
it open.
Miss Williams.
That's fine.
College relations. You just,
Okay.
My only thought about that is to clarify, it seems like it's unnecessary to say we could designate a representative. I would just think clearly we could do that. But maybe we want to make it clear it could be a board member. So we could, it's a thought that we could designate the chair to give that information. Otherwise, I'm just not sure. I can't believe it would come into question that we could designate somebody to answer questions.
Well, I don't know.
how about if we
So
add, the board may
Yeah,
designate,
I thought it was a representative including the chair. I guess I would designate the
But
I
what
don't think we
happens,
can do
I
that.
mean, what happens if the chair knows all the applicants? I'm not, I'm just saying any chair.
Well, then we wouldn't designate them. We'd say
Okay,
you've got to
so-
go to,
That's why you want to
To-
leave it open, right? Just in case of those boundaries.
I just don't want the first
Yeah.
sentence to say that we're not going to have any communication to say, well, then the next sentence must mean that we can't designate a board member because we just said they can't have any contact. So
Gotcha, yes.
that was my only thought, is that we want to clarify that this is kind of an exception to that, which is
Yes.
a board member who we have designated for this particular purpose would be allowed to have that contact. Does that make sense?
Yes. Kind of contradicts itself.
What if it said the board may designate a board member or other representative?
That's
During-
fine.
During a
I like-
but
like
again,
that.
yet, so you want to take out the word avoid, right? Because it's so contradicting itself if you're going to appoint someone.
No, I think it's okay.
I think that, again, clarifies that that's not what we're trying to avoid. That person we've designated
Right.
would not have to avoid
Okay.
communication because yeah. And my only other thought was, are we saying you can't have any communication? And this is where I come up with, you're at the Christmas party, if we ever have Christmas parties again, and you're contacting, it's really communication about the process, or do we want to say communication which would give an advantage to that vendor or applicant? Or is it just easy enough to say this process, don't talk to them?
My personal feeling is these processes don't last forever when it comes to selecting a vendor or appointing a regent. And I mean, as a regent, I would be comfortable telling somebody, while this selection process is ongoing, I need to not have any contact with you right now and let the process play out. And I think, I think folks would understand that.
Okay, I think that works, that it's not really, saying hi or how's the family is not really that kind of communication. So I'm good with that, Libby. Let's not complicate it.
But I think it also protects us that if, a potential contractor or vendor wants to innocently take us to lunch, and if somebody may see us at lunch, and this may be somebody who I know personally, that given the time frame, that's not a good time for us to go to lunch, even as friends.
That's good. I like that explanation. Thank you.
Sure. Okay, so I think we're good with that, Mr. Rivera,
Sounds like
with the edit that you made to that.
Okay.
Okay, section U, you have shortened, which is unlike you.
It's called tightening. So hopefully tightening and clarifying made it what you all hoped to get there.
It's the same, yeah.
Uses fewer words, and I think part of the problem was the concept of tending to appear to influence just sounded strange. So I think
And we don't have to figure out what the intent was.
right, exactly.
I like this.
I think we're comfortable with that.
Okay.
Good, thank you.
All
Okay.
right, on to
W,
the
which is
problem child.
the longer one.
W. So, a point of personal privilege, I do like this. I do like that you all are stepping out and doing this, because this is unlike other, any of the other code of ethics that we saw, frankly. And it's not, like I said, a concept that's unique. I mean, at the state level and at other, with respect to other governmental entities, you have to be careful about what you do after you leave. And the revolving door is intended to prevent someone from serving on a board and then getting off and then coming and lobbying or coming and appearing in front of that board the very next week. It doesn't look good to the public that you've done that.
Right, and we make a statement to the business community that if your intent is to hire a regent within a year after he or she leaves that position in order to potentially get some inside information or
Get a
specific
contract.
relationship or access, that's not something that we're interested in, and that we won't do that as regents.
So I've got 3 different versions. Every one of them lengthy, I'm afraid, but the first one
May I speak to the first one? Because
Sure.
that was my language.
Absolutely.
The first one, I wanted to make clear that we were talking about 1 year after leaving office.
Right.
And also, I wanted to keep the focus on an employment or business relationship that would put the regent in direct contact with the college. And contact may not be the appropriate word there, but what I recall from our meeting was we heard lots of scenarios about, well, you know, what if I go work for a company or am self-employed and work with a school district who may have a dual credit program with Del Mar and they want to hire me, you know. To me, the issue was not so much that the former regent gets hired, but that the former regent is then doing business directly with the college. But I can also live with, don't be hired by anybody who's doing business too. So that's why I came up with the language for the first one. But that also may be window dressing, because the fact is, who knows what happens in a closed door conversation back at the office, even if the former regent is not dealing with us directly. So
Well, but you tapped into something about the direct contact. I mean,
I think that was our discussion, was that direct contact.
and
I think
that
was our
yeah.
focus.
So what I've done with the second and third options, I've changed the rhetoric on it a little bit. You'll see the way
okay.
that what you're asking each other to endeavor to avoid is the possibility of conflict of interest or the appearance of such conflict. And that's language, again, that's language that I've borrowed from the authoritative source. If the regent takes employment or enters into a business relationship with a vendor, with any vendor, takes employment on a particular matter in which the regent was personally and substantially involved while in public service. So that's another angle or approach to it.
Okay, let's not leave that one yet, because I want to ask you. So this would bar, understanding that this is more aspirational than anything, but if it's an employer who has an existing business relationship with the college in which the regent was somehow involved. So if the if whatever that company does with the college never shows up in front of the regents, then that would be fine.
Right.
Okay. Which did come up in our discussion on the 10th.
Right.
Okay.
That may not be the clearest way to state it, but that's exactly what that's directed at.
Okay.
And then the third option takes that aspect of it, that is the particular matter part, but then also adds it's a little bit of a variation of what you brought up, Regent Averett, which is if you get hired and you're required to appear before or communicate with the college or the Board of Regents, and that's something you should also avoid.
Susan, do you have thoughts on these?
Yes, I'm tending to like the first one because I do think it just makes it clear that it doesn't put you in contact. And I think what some of the examples that were brought up was, you know, professionals, public relations people, lawyers, whoever, who have a client which doesn't involve any contact with the college. They just happen to be in that position, so there's no opportunity to use any influence there. So I think that takes care of what I heard to be one of the biggest concerns, is if you just happen to work with a vendor or a client in that respect. If we limit it to having had substantial involvement, now I'm talking about the second one, substantial involvement with the process, then that doesn't close off new matters. It has to be something that you had voted on while you were there, whereas I don't know that it takes away all the conflicts of interest. So that one just seems problematic. I'm not quite sure what it achieves that the first one doesn't.
Okay.
So I don't know that the first one takes care of everything, but I think it doesn't overreach and take care of more things than we wanted to.
That's why I wanted input, because again, you know, it may be broader or just too big an umbrella for what you need, what you're trying to address.
Yeah, because I tend just to go for the first one as well, because how in depth are you going to go into someone's life? You know, and I just think it's just, I think our attention was that direct contact. And I don't know, I'm always for more, I think the other ones are just complex, and I just want to keep it very concise and very easy reading, and just making sure that our points are in there.
So even though I wrote the first one, I am now a little bit concerned that it does only address a situation if the former regent would be in some sort of business relationship directly with the college. And so that doesn't protect or it doesn't prevent the regent from trying to use former relationships or quietly behind the scenes.
But how are you going to avoid that anyways? When it's behind the scenes, that's what I'm talking about. How in depth are you going to go into someone's personal life?
Well,
But I think, Libby, you're right that what you've just described is still contact with the college. So if it involves your, you know, smoozing with a college representative in your capacity with that business, I think what you've written would outlaw that.
Yeah.
No, what I'm thinking is that a former regent takes his or her knowledge, and perhaps even confidential knowledge, of how decisions were made or how the process may work or where we may be headed, and shares that information with their new employer,
But how would
even
you
if that regent never has any direct contact with the college, but basically downloads all that information for the benefit of their new employer.
But how would you stop that anyways?
Well, I'm well aware that 90% of this is relying on somebody's
I
own
know.
conscience, and that they will
So,
do the right thing. But I
yeah.
think it's important that we put in writing what we think the right thing is, because I think that says something about us as regents.
Well, I would hope the things we've already pledged about confidentiality would cover that. If it truly were confidential information, we've already pledged that we're not going to share that information. I assume that means ever to anyone.
And I was thinking, as we were talking about this, at the risk of making this longer, that we add to the first one, you know, some language about a regent must always remember their duty to confidentiality, you know, something that
Well, that would work.
that reinforces, you're right, Susan, what we have already pledged, and that those responsibilities carry beyond just our specific years on the board.
Yeah, what if, I always hate to just remember one thing. They also need to remember this other thing and this other, you know, we've said a lot of things. I don't want to have to pull it all back in, but I like your idea But what if it was something like that last line and a half was, if such employment or business relationship puts the former regent in direct contact with the college, or puts the former regent in the position of violating some other duty. And I didn't say that well at all, but you know what I mean? That puts them in conflict of interest or jeopardizes their other ethical promises. Not very well said, but I'm just trying to make it broadly that, that we don't want you going and breaching any of these other ethical things while you're out there.
The tricky part that I would remind you all is that it's not, again, you know, the most important part of this is that you may be addressing the appearance, so that it's not even whether, you know, any one of you after you leave would actually do something like that, but what's it going to look like to the public? That's what, this is exactly what I was hoping for, input from you, and what you're, you know, what are you trying to address here? And what you want is, you don't want to, you want to make sure that after you leave, that you're not engaged in conduct that's going to, even though you're no longer on the board, is going to raise a question about the integrity of the board.
Well, and let me give you all a hypothetical even on the first one that would not be addressed, because it is limited to businesses who are currently in a business relationship with the college. Let's say I resign or am not elected again, or at all, and, you know, a month later, a company hires me, and 2 months after that is bidding on a project. This would be fine if they wanted to appoint me as the spokesperson for that company to try to win this contract. Since it's limited to which the two other options are not, correct, Mr. Rivera?
That's right.
I mean, I can't believe I'm going to say this. I actually prefer the third one. I know that it's long.
Well, I guess my question is, so what additive is there? I mean, is there something that's really changing the first one? What, I mean, when you read the statements, does it really change the intention of the first statement? What has changed? Because I guess for me, I don't really see it as much of a difference. And that where it's going to totally impact and change the way I live my life. You know what I mean? Is there anything that's going to make me not get hired, and a year later I'm standing here and I don't give out all my secrets? I mean,
Are you asking what the difference is between the first proposed?
So what's the additive
bet-
that actually like changes and adds to what we are trying to accomplish?
Right, are you saying based on the proposed first one and third one, or the current?
No, the proposal, because I know that I believe that we're going to change the current.
We are.
So so just reviewing and looking at the proposals, the choices that we have, is there really, is the second W adding anything really different to the first one?
Yes,
'Cause
the first one is limited to businesses that are currently doing business with the college.
Okay, so
The second and third one are more broad.
Okay, but what's the additive, I guess? So like direct contact with the college and future contracts, so maybe current and future direct contact with the college. I just think it's just wording. I just don't want people getting lost in what the message is. That's what I'm afraid of. Because I was already like, so I was just trying to figure out a way to maybe just add a couple of things to add to if you, I don't know if I'm saying that correctly.
Let me just throw out, maybe this, if we added to the first one, let's go back and see, because it is simpler. But it does seem like we need to add not just having direct conflict, but we also want that employment not to give the appearance of a conflict of interest. Is
Right.
that it?
Well, and,
is a really
and to address
statement.
potential future business relationships,
So-
not just current business relationships.
So is there a way we can add that, current and future? Because that's the issue, right? Current and future.
Yeah, to me, just adding giving the appearance of conflict of interest, and I'm not sure if that's the perfect word is conflict of interest, but something unethical. It adds that broader statement of just don't go work for somebody and then get into something that appears to be a conflict, that you've taken advantage of your office. I worry in the second and third one, what's really bugging me there is that particular matter.
Okay.
I don't want it tied to something that the former regent had actually voted on. I just think that's not what we're looking at. We're looking at
Okay.
using their office in an unethical way. So that's why I kind of go back to the first one and say, what can we just add to make it so that it's not just direct conflict, not just direct contact, but it's doing something unethical. And I know that, and the only thing I can think of is that appearance of a conflict of interest. Does that move the ball forward at all?
What have you, looking at the second option, if you just put a period after currently in a business relationship with a college?
Okay.
But doesn't add to the future. I don't think any of them applies to the future. Right? So we would need to add that language.
Well, what if we just took out current?
Exactly.
I mean, how do you say you can't take an employment with somebody that might be in the future have a relationship? I mean, that's.
So you take out the word current?
Well,
Yeah, what if we took out currently and just said,
I'm with you. So endeavor to avoid for a period of 1 year after leaving office, both the possibility of conflict of interest and the appearance of such conflict that would arise if the former regent takes employment or enters into a business relationship with any vendor, contractor, company, or other individual or entity. Period. Is that too general?
Well, I think you want that direct contact in there, correct?
I'm not tied to the direct contact.
You're tied to the
What you're saying generally as an aspirational statement is that you shall not take any employment after you leave the board for a period of 1 year that would put you in a position of a conflict of interest or the appearance of a conflict of interest.
I think I would leave in a business relationship with the college, because otherwise that seems awfully broad.
Okay.
Right.
You know, it's kind of what else would we be talking about other than one that had a business relationship? I think I would just take out the currently, and that
Okay.
just means if you've got and again, it's not precise, but luckily it's not something we're going to be litigating. It
Right.
is an aspirational statement generally, that the whole idea is that we don't want people who are in business with the college benefiting by hiring a regent.
Right.
And I kind of think that says it if we stop after college and take out currently.
I think,
warming up.
I think I'm with you on that. Since we've added in the conflict of interest language and the appearance language, because there, I mean, I know it's all subjective, but there could be employment. You know, I'm thinking of a lawyer who is hired by somebody who works for the college or whatever. I mean, that's not a conflict, right?
Right. Right.
Unless they, unless they're having some direct contact. I mean, unless they're doing something in that employment that does create that conflict. But I think as long as we put it to the point that it has to be a conflict of interest or appearance of a conflict of interest is what we're trying to avoid.
All right, so we're looking at the second W and removing on a particular matter in which,
Right.
correct?
And removing the
That's-
word currently.
Yes.
So back to the lawyer example, since we have two in the room, would this prevent a former regent who happens to be a lawyer from being hired by a former employee?
Against the college, yes.
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 Okay,
And that might be lifetime ban, frankly, because there are things that you hear in closed session that you know that are confidential, that you'll never be able to, come back and sue the college.
as lawyers, though, you have your own standards.
Right.
And,
Yeah, we don't have to,
Right.
we don't have to govern that.
right,
Right.
okay,
We, the board, yeah.
right, yours are much more strict.
It leaves, so the con, okay, the counter to this is that, like you point out, Regent Hutchison, it's not very specific. It kind of leaves it subject to interpretation. On the other hand, it makes the statement maybe that you want to be making, which is really the point. And I can't think right now, but I mean, we could add a sentence in there that's even more direct. I mean, after all of this, that this is intended to, prevent a scenario where a regent is seen as benefiting or something. I mean, I don't know.
Could you
I
put
guess I
that
can't think of it.
And,
But you said it earlier, Susan. I should have written it down.
well, could you,
Well, yeah, the problem with adding specifics is it kind of eliminates the others.
That's
Right,
right.
if it's for
That's true.
this, then it's not for those. So, yeah, again,
Okay.
if it was something we were really trying to enforce, I would want some specificity. But if we're putting a pretty broad conflict of interest, which could cover lots of different actions, but it wouldn't cover the actions that we didn't want to cover, such as just representing a client who's in some matter completely unrelated to anything about the business that's being done with the college.
Okay. I think I'm comfortable with that. I will say I suspect we'll have more conversation with the board, which is good. That's welcome, certainly. I would like us, Mr. Rivera, to be as prepared as possible to address board concerns at that meeting in hopes
Okay.
that we can come to a decision at that board meeting so that we don't keep kicking this can down the road.
The easiest way to, I mean, I think Regent Hutchison nailed it. I mean, it's aspirational.
Right.
So we're not going to be litigating this. This isn't
Right.
something that any of you, the board won't be able to sue. You won't be able to report this to anybody. It's not it's,
we're just setting the standard.
you're setting a standard.
We wouldn't even be able to sanction somebody because they're not a regent
That's right.
anymore.
They
So
won't be removed from office.
I think what we need to be prepared for is some what ifs. I think there's going to be, does this mean I can't do this, or does this mean I can do that? And hopefully the answer is going to be well, is there a conflict of interest? Is there appearance of a conflict of interest? That's your answer. But
Right.
Yep, I think so.
And Mr. Rivera, I think it's appropriate, especially on this one, if before our next board meeting, you could reach out to a couple of our regents in particular who had questions about this and just kind of talk through it with them.
Sure.
I think that would be helpful.
What I'll do is I'll clean this up and circulate it amongst the three of you for
Sure.
sure. And if you have other questions before the next meeting, you can call me one-on-one.
Okay,
Because you may have other thoughts after this
Sure.
percolates a little bit. I realize I just got this to you this afternoon, so I'm sorry about that. But you can see I worked at it, and just Rubik's Cube this one in particular, because there was a lot of concern about it.
absolutely.
So-
Thank you.
Well,
Thank you
I
for
tell you
that.
what, I really appreciate both of you and Augie and everyone else that helped with this. If this is only the issues that they discussed out of all the changes and everything that we have done, I'm really proud of our group.
They were
yeah.
very appreciative of the committee's work,
So-
too. So let's talk about the personal
Okay.
disclosure statement. You shortened Roman numeral 1.
I did, and so what I handed out to you, Regent Turner and Regent Averett, are just so that you can see what this personal financial statement form that's put out by the Texas Ethics Commission actually looks like. And I included the index, which has 20 parts to it. These are, it's an online form. Part 1A is sources of occupational income. They don't even, they just ask whether you're employed by another or self-employed and the nature of your occupation. That's it. That's all they ask there. But then they get into Part 1B. That's where they start asking about retainers. And it's rather lengthy. This section concerns fees received as a retainer by you, your spouse, or dependent child, or by a business in which, anyway, it goes on and on and on, and it's for a claim for a claim on future services in case of need. So that's what you have to fill out if you're filling out this state form. From everything that I heard, and to avoid any confusion and to make it not oppressive and onerous on you, it seemed to me that from your conversation that everybody would be comfortable with just listing the sources of occupational income identified by employer or if self-employed by the nature of the occupation, and that would take care of it. Now, maybe that doesn't go far enough, because if you're a consultant, for example, and you have a list of clients, that might be important, it may not, I don't know, so.
I have a quick question.
Sure.
Under the government code, who does have to file this statement?
There's a list, state agency employees. This is the form I know that the city uses as well. I don't have that in front of me, but you all don't.
So the city council uses this form. Does the county commissioners court?
I don't know. I don't know off the top of my head.
I know if you're a
I can
judge,
look it-
though, I mean, any
me see.
city, any state appointees, we had to fill all of this out. And you are given a flyer ID, and that's your ID until you die.
And so this is the personal financial statement as defined by the Texas Ethics Commission,
Right.
that certain employees must file,
And public official.
and public officials.
Uh-huh.
We do not have to as
Community college.
community college regents. But have we ever discussed us filing these?
No. You can.
So, Susan, you're at a bit of a disadvantage. I don't know if you have this in front of you or not. And I know I'm not trying to increase our workload, but this is the first time we've seen this
Right.
statement in this committee meeting, and it's the first time that I've become aware that this is what city council members fill out who are elected.
And not only that, but I also had to, when I filled this out, I also had to include my husband's income because that was part of our family income.
Sure.
So it was, yep.
I personally am in favor of us adopting this. I personally think that if city council members are required to fill this out, that we could volunteer to fill this out.
Okay.
I'm not sure how the board will feel about that. or how the other members of the committee feel about that. Susan, do you have the form?
I have the short form. I don't have, you've got a long form. Is that what I understand? I'm not sure what I don't have. I just have that, just the one-page draft of a personal disclosure
Yeah,
statement.
no, this is, yeah,
No.
I'm gonna
No,
scroll.
I don't have that other.
This is a Texas Ethics Commission form that is a multi-page form.
Yeah, because in reality, it's like 20 pages long, depending on, you checked all the boxes.
This seems like a whole new, not totally new issue. I know we talked about it, but it seems like it's going to take a whole another study. Would it be out of line to punt this one for now, or do you really want to get it part of everything else that's getting changed? I'm
Well,
torn.
we did talk in the last board meeting about getting a copy of what the city council members are required
Right.
to fill out.
I did
I would
Get a
ask,
feel for what people were wanting to do. Did you? The rest of the board?
well, I think the entire board was comfortable with finding out what the city council had to file. I would ask that we also find out what the county commissioners court is required to file.
So the list is appointed officers of executive branch state agencies, executive heads of state agencies, board members and executive heads of river authorities, office holders and candidates for the legislature, statewide elected officer, justice of the Court of Appeals, district judge, district or criminal district attorney, member of the State Board of Education, former or retired judges sitting by assignment, state chair of any political party receiving more than 2% of the vote for governor, and the most recent, so it's pretty,
It's extensive.
it's extensive, but it's not everyone.
It's not local school boards,
No.
is it?
But with the city committees also, anybody else serving on a city committee. they'll have
Really?
one as well. It may not be as extensive, it's a shorter
Yeah.
version, but they do.
Is that
fill out-
new? Because
they
I
do
never
fill out
had
the
I never
financials
filled out anything for city.
And spouse financials as well, mentioned earlier.
So to Regent Hutchinson's point, I think it is something that we'll need to, I don't want to say punt, but I think we will have a discussion about this at the board meeting.
Your recommendation can still be, you've in essence recommended to them that a personal disclosure statement be filed, that there be something that you do. And now you're, wanting to have a larger discussion about that, a bigger discussion about that. Because you're right, Regent Garza, who's very familiar with the filing of this form, said, I know what that form is, and we have to do this. Regent Bennett, and that's why I added on what you see there in terms of the note, personal, liability.
Well, I would like to provide to the board, when we report back to them, your proposed edits for what they've already seen, because they've seen this shortened form. So
Right.
I'd like them to see that. I'd like them to see what the city council is required to file.
Okay.
And potentially what the county commissioners are. I just don't know enough to know if that's a different form. And for us to start the conversation in that board meeting about whether there is some will for us to hold ourselves to a higher
Okay.
standard than we are legally required.
That is totally within your charge. It's part of the bylaws review and, your ethical, and review of the ethics. Okay, we can do that.
Are you comfortable with that?
Yeah, I like to see what their forms look like in the county. And maybe probably adopt one of them that they're using versus designing a whole new one. You know what I mean?
Oh, right, I agree.
Yeah, I don't
I'm
want to
comfortable with us basically doing what's required of other governmental bodies already.
Nothing less, nothing more.
It'd be easier on my end. I wouldn't have
I
to
know.
try to
Yeah, that's what I'm
summarize
saying.
and
Find out
create a
what
new
they
form.
do, and we'll just
But it'd be harder
adopt
for you
one.
guys. But,
Yeah.
you know, again,
It actually doesn't take very long
It's-
to fill out. It's all on computer. You just,
great.
yeah. And once your information's in there, it's like your taxes, it's already there. You just update it year after year.
I can
Reg-
do that.
Regent Hutchinson, are you comfortable?
I am. I'm really at a disadvantage without knowing what it is. I don't want to impose anything onerous that doesn't really do us any good, but I am respectful of the idea that if it's what's good for council and other fiduciary bodies, that we should certainly look at that.
Right, thank
But
you.
if you'll mail that to me,
I will.
that'd be great.
I will.
And any other forms that you find. I mean, what I do like about this one is obviously it's used by a number of bodies. Okay, Mr. Rivera, anything else?
That's all I have. Regent Averett, again, I hope I captured everything and caught all the details. You know, we went back and Ms. Sanchez helped me by going through the minutes, and I compared that with the notes. And like I said, there was considerable discussion about some of the other points, but I think you all addressed it. Trying to remember, there was one point in particular that was raised, but I think you were able to answer most of their questions.
Okay,
They wondered about, for example, the inclusion of all the detail about the public comments, and you all responded. You thought it was important to lay out the process. One thing, there was a mention, and I know Regent Scott brought it up, and then Regent Kelly did as well, about, well, can we put something, since we do have some citations to some state statutes, you know, or as subsequently amended. Let me tell you why I didn't do that. I'm not comfortable with that. I mean, it's my experience that if the legislature is going to change the law, you want to look at it. And if it requires you to change things or take it out, I think you take it up on a, you know, as it's amended. But to put something in that says, or as subsequently amended, causes me some concern. So,
okay,
requires us to be vigilant and make sure that Dr. Villarreal does her job every session and keeps track of the changes in the law, so. But other than that, that's all I have.
okay. Regent Hutchinson, do you have anything else?
Nothing more.
Dr. Turner?
Good job.
Okay, with that, we will stand adjourned at 5:27 p.m. Thank you all. Thanks for your attention.
Thank
Thank you, Susan.